Washington Journal continues.
And joining us now from New York City is New York Times reporter Jessica Silver-Greenberg. She's here to discuss a new Consumer Financial Protection Bureau rule that would allow consumers to join class action lawsuits against banks and credit card companies. Jessica, thanks so much for joining us today.
Thanks for having me.
So explain to us exactly what this new rule on mandatory arbitration does and why it's happening now.
Okay, so in its most basic form, the rule says that financial companies, so banks and credit card companies, and other kinds of lenders, can't force their customers as a condition of signing up for a product to agree to go not to court, but to mandatory arbitration. So that's on its face, that's the kind of most basic thing that it does. What it really means is that the Consumer Financial Protection Bureau is shifting power from Wall Street financial firms to consumers. And why it's happening now is, that's a more complicated question, but the CFPB, shorthand for the Consumer Financial Protection Bureau, has been studying this rule almost since its inception in 2010. So they have been on track to put out this rule, which was really a centerpiece of the agency's work.
And you write in your piece in the New York Times about it that this rule would, as you say, pry open the courtroom doors for millions of Americans by prohibiting financial firms from forcing them into arbitration in disputes over their bank and credit card accounts. The action by the CFPB would deal a serious blow to banks and other financial firms, freeing consumers to band together in class action lawsuits that could cost the institutions billions of dollars. Talk about what the potential impact, a little more about what the impact of this rule might be on banks.
Well, what it will do is it will open up the floodgates, so to speak, to enable, like you said, groups of consumers to come together to pool their resources and to contest questionable business practices, illegal practices like predatory lending, discriminatory lending. So what this could mean is a restoration of the kinds of class actions that financial firms were so intent on quashing when they set out to use arbitration to kill these kinds of lawsuits about, almost a decade ago.
So,
2 decades ago.
Yes. So let's talk about the broader fight over the CFPB itself. A lot of Republicans and business groups have been very critical of the organization and its chairman, Richard Cordray. Let's take a look at an April 5th House Financial Services hearing about the CFPB and remarks from Republican Congressman Jeb Hensarling.
For conducting unlawful activities, abusing this authority, denying market participants due process, Richard Cordray should be dismissed by our president. Not only must Mr. Cordray go, but this current CFPB must go as well. American consumers need competitive markets and a cop on the beat to protect them from fraud and deception. They don't need Washington elites trampling on their freedom of choice and picking their financial products for them. Today, Mr. Cordray and his CFPB don't just act as a cop on the beat, they act as legislature, prosecutor, judge, and jury all rolled into one. CFPB represents the summit of unelected, unaccountable, and unconstitutional agency government. It represents a dagger aimed at the heart of our foundational principles, namely co-equal branches of government, checks and balances, due process, and justice for all. Clearly, you can be a Democrat, uppercase D, and believe in the CFPB, but you cannot be a Democrat, lowercase d, and believe in this institution. Thus, this debate has import way beyond the fate of fines, credit cards, and mortgage access. It represents nothing less than one of the key battles to defend and protect our Constitution.
So can you put this new rule in the context of the broader fight over the CFPB?
Yeah, and I can. And to just, it's interesting because Representative Hensarling brings up this idea that the CFPB is, preventing competition, preventing choice among consumers. But it's interesting because this kind of signature rule that they have now proposed, this ban on arbitration clauses, actually restores a lot of competition to the market. I mean, what's interesting is arbitration has successfully derailed challenges by consumers to anti-competitive business practices, things like wage theft and fees that are anti-competitive fees that are charged. So, I mean, in terms of restoring these competitive practices or talking about a check on monopolies, this rule really it gives consumers a lot more power to exercise that freedom of choice. So that's one thing. The other thing is it's a pretty bold move on behalf of the Consumer Financial Protection Bureau to put out this rule now, especially because they are under fire. And I think what it marks is it's a reassertion of the agency's independence from Congress and from the prevailing political forces in Washington right now.
Okay, we are talking with Jessica Silver-Greenberg of the New York Times about a new rule from the CFPB that would allow consumers to bring class action suits against credit card companies instead of mandatory arbitration, as was previously the practice in many contracts. Democrats can call 202-748-8000, Republicans 202-748-8001, and independents 202-748-8002. Robert's on our Democratic line, calling from Harrison, Arkansas. Hi, Robert.
I'm glad to see this come to light. You should not have to waive a constitutional right to take part in the economy. When a few years ago to get a contract on your phone, you agreed that if you terminated, you would pay them so much money. But on the other hand, they could change the terms, the fees, the conditions without any notice. You agreed that no matter whether it was fraud, breach of contract, any other theory of liability, you agreed that you would waive your right to a trial by jury and go to a binding arbitration. Whenever there's a contract change, each party should be able to look at their own positions. We entered these contracts for 2 years, for example. You have to look at your conditions just the same as they do. And when they find a need to change their contract, well, then you should also be able to look at yours. So I think this is an excellent time to look out, and you should never be forced just to participate in the economy to waive your right to a trial by jury. Thank you.
Okay. Go ahead, Jessica.
Well, Robert, thank you for calling in. And one of the things that you point out, which I think is very interesting, that shows kind of the impact of this rule is, can you imagine, I mean, you're right that effectively what arbitration clauses did was they forced people to, in exchange for opening that bank account or renting that car, to waive a fundamental constitutional right. Can you imagine if, as a condition of getting a car or a bank product, you had to waive your Second Amendment right? I mean, we would see a lot of, I think, outrage. So I think many people have signed away their right, waived that right, without even fundamentally realizing it.
All right, Craig's calling from Trenton, New Jersey on our Democratic line. Hi, Craig.
Hello. Hi. I have a sad story to tell you. My ex-spouse, at the time we were getting divorced, I found out that Bank of America had issued 9 different credit cards to her, each for $10,000. And naturally, she had run up the cards on gambling in Atlantic City, hotels, cruises, and just basically wasting money. And there's no recourse that you can go back to the credit card company and tell them this is just nonsense on your part. You know, one card would have been more than enough. And certainly by the time they issued 9 cards, they knew this was just nonsense, and they just came across with the credit card with knowing that nothing could happen to them. You can't sue them. As soon as you sign the back of the credit card, there's a little couple words on the back that you agree to binding arbitration. So there's no legal recourse.
Well, Jessica, would this rule provide relief for people like Craig?
It would. Well, in new credit cards that, Craig, if you took out a new credit card or a new loan, you would be protected under this new rule if it goes into effect. And what we found, so the New York Times, we did a investigation of arbitration and just how many people had gone to arbitration over a financial dispute in a period from 2010 to 2014. And in that time, what we saw was, particularly for financial disputes like the kind you're describing, Craig, very few people, once they were forced into arbitration, actually went forward with it. So for the financial firms, arbitration bans have been very powerful, very effective in derailing consumer complaints or challenges to business practices like the ones you're describing.
So a couple of accounts sort of show the different sides of arbitration, the results through arbitrations as well as results through class actions, and neither one always give great results. USA Today, which calls it a rip-off clause, the mandatory arbitration clause in a piece, points out that consumers have narrow odds of winning at arbitration. It says the odds are stacked against consumers when it comes to arbitration. They lacked the institutional knowledge of banks whose legal teams are familiar with arbitrators, and that's partly why there are so few cases. Only about 400 consumers file arbitration per year against financial companies. But on the flip side, there's a piece in the Washington Post today, an op-ed piece, that says the rule on class action is a win for all, even if it doesn't seem like it. And it points out that it's bittersweet, writes Michelle Singletary. She says the rule change is a win for sure, but not necessarily for aggrieved individuals who may dream big of a big settlement in court to punish wrongdoing. In the class action cases, lawyers can walk away with millions. Consumers may get some money, but seldom is it a huge payday. Individually, it points out that some recovery is as low as 3 cents. So talk a little bit about what consumers can expect from this change if they actually have to bring some sort of action against their card companies.
So a lot of people focus on the amount of money that's returned to consumers in class actions. And proponents of the rule and legal scholars who have studied class actions and their role in a functioning democracy talk about their purpose being not to deliver huge payouts to large groups of consumers, but to deliver small amounts of money to across a large group of individuals who have been harmed. And kind of more fundamentally, the idea is not the financial payout from class actions, but the ability of these class actions to fundamentally uproot unfair and illegal business practices. So to force companies, in other words, to change.
And one case of that, I guess, would be the Wells Fargo, which recently paid $142 million in a Fink account settlement. According to USA Today, again, they'll pay that settlement to customers whose credit card score have been hurt by its employees' much maligned practices for creating fake accounts at bank branches. So in that case, it's $142 million. Each consumer may not get that much, but the impact is felt on the bank, right?
Right, exactly. And there's another class action that some people point to, which is for a long time, some car finance companies, so some car dealerships, were charging minority drivers more than their white counterparts, even if they had the same credit score. And there was a class action that was brought against a number of the dealerships, and it successfully changed the practice so that minority drivers are no longer, at least in these cases, they were no longer being, they were no longer paying a premium for their race.
Okay, Thomas is on the independent line from Bennington, Vermont. Hi, Thomas.
Good morning. Thank you for this wonderful program. I'd just like to bring up Puerto Rico because it's in a very bad situation, financial straits from hedge funds, big banks, and insurance companies. And go back to 2008 where the $700 billion, we bailed out the banks. And there's two people like Richard Wolff and Jar Aponovich, economists, who said that we should have gave the money to the homeowners. It would have been better for the economy. And I thank you very much for your program. Bye.
Go ahead, Jessica.
Thank you for that call. I mean, I think one of the things that just to look at the Consumer Financial Protection Bureau and in the broader context, it was created as part of the 2010 Dodd-Frank Act, which was put in place in response to some of the abuses and the harm that we saw from the mortgage crisis. So this agency, at its kind of origination, was designed to protect consumers, protect homeowners from what the caller was describing.
Okay, Linda's on the line from Salem, West Virginia, on our Republican line. Linda, you are on with Jessica Silver-Greenberg. Linda, are you there? All right, we're going to move on to Juanita, who's calling from Cincinnati on our Democratic line. Hi, Juanita.
Hi, and before I say anything, I just want to say to the hostess, you are so pretty. You look beautiful this morning. In regards to Mr. Cordray, he was our Attorney General here in Ohio, and he was a wonderful, wonderful AG. He helped my mother and I in 2009 when the banks plummeted, and all of our credit was fine, and they came with that spiel. Then they turned around and sent us a $100 cash card that we could use because they thought we were short of money. We sent that card to Mr. Cordray in Columbus because Citibank claimed up and down that they were not affiliated with the bank. We would have nothing to do with it. I am so absolutely ecstatic. And one other thing, we won the class action suit. The reason I can tell you that, IRS taxed me $245 for income for the money that Citibank tried to charge us. And I want to thank you. Thank you. Bye.
Go ahead, Jessica.
Rich Cordray is a very polarizing figure, and I think that, as the director of the agency, he's weathered a lot of abuse. And I think to our caller's point, I think that a lot of consumers who lived in Ohio and who have been beneficiaries of the rules that have been put forth by the Consumer Financial Protection Bureau are very grateful.
And just talking about the different views about Richard Cordray and the CFPB in general, the U.S. Chamber of Commerce this week released a statement calling the new rule the CFPB's, quote, brazen finalization of the arbitration rule. They called it a prime example of an agency gone rogue. Also, Congressman Hensarling has warned Richard Cordray that in an attempt to follow through with this rule could lead to contempt charges. Talk a little bit more about that fight.
So the CFPB has long been, really since its inception, a thorn in the side, I think, of banks and Wall Street companies. But it's also been a target for a lot of ire from the Republican Party. And that's what you're seeing here, too, with Representative Hensarling. He did send a letter to the CFPB director, I think about a week before the final rule was put out, where he said that he threatened to hold Cordray in contempt for not complying with subpoenas that he had sent related to the communication and discussions around the arbitration rule.
Hey, Ted's calling from Jackson, Tennessee, in our independent line. Hi, Ted.
Good morning. Listen to Representative Hensarling there. It's almost laughable. For him to say this is an attack against the Constitution, oh, me, it's quite the contrary. I'm so glad that they're doing this, the CFPB. Just to give you a little example, my bank, I've always had done my online banking, and so when the bank was bought out by a larger bank, I had to sign this agreement, and the agreement was that there would be no trial by jury. Well, that's taken away from the Constitution. It would be anything contested, would be arbitration. If that's going against the Constitution, I'd like to know what is, Mr. Hensley. I'm so glad they're doing this. It's standing up for the little man.
Go ahead, Jessica. You respond?
Well, it's a thank you for calling in. I think that's a really interesting point that you make. And I think that proponents of this ban on arbitration would agree with you and would say that this rule does restore a right that many people didn't even realize they were giving up. So they didn't understand when they were signing or clicking on that box that said they agreed to mandatory arbitration. Until they have a dispute that requires them to go to arbitration, they don't really understand the impact of that, of being shut out of the court.
Okay, and we are talking with Jessica Silver-Greenberg of the New York Times, formerly also of the Wall Street Journal and Business Week, about the new mandatory arbitration rule, the rule that allows consumers to sue class action, bring class action suits instead of mandatory arbitration to card companies. Donna is calling from Florida on our Republican line. Hi, Donna.
Hi.
Go ahead, you're on with Jessica Silver-Greenberg.
Okay, Jessica. I've had a problem with Wells Fargo in my local town where I live, and my husband passed away March 17 of 16, and we had always had joint accounts, savings and checkings accounts, and when he passed away, I was not aware that the savings account was only in his name. Now, the bank had different times that I'd been in there, and they could have informed me of this, and they did not. So my Social Security check was going into that account, and it was $100 a month that I had put into the savings to help pay for my property tax yearly. Now, that amount that was in there at the time, to me, it was a lot, and to other people, I'm sure it was not. And so there was an issue that I had received a call from somebody saying they were from the bank, and they started telling me about the account. And I felt suspicious about this, so I alerted the bank about it. Then the following day, I went to my local bank, and I talked to them about what had happened previously the day before, and they said, well, that's true that your account, you can't use it. And
well, Donna, I just want to, we're running a little short on time. I want to ask Jessica, what should customers who are having issues like this with their banks, what would you suggest that they do? Should they contact the CFPB?
I think the first route is to contact the bank, and then and the CFPB is also can be a tremendous resource for people like Donna. There is a repository of issues that consumers are having, so that can be another route. And depending on the conduct, you can always contact your state attorney general as well.
Okay. Paul's calling from Indianapolis on our independent line. Just a few seconds left with Jessica Silver-Greenberg. Paul, go ahead.
Yeah, two quick questions. Couldn't we just have somebody better pick the arbitrators rather than giving the trial lawyers a huge benefit? And secondly, can't we, isn't the real problem with the CFPB is the fact that they're totally independent without Congress controlling their budget? I'll take my answers off the air. Thanks. Bye.
Go ahead, Jessica.
Okay, two very quick points. One is the arbitrators, it's not really about what happens in arbitration, because what we've seen is very few people actually end up going to arbitration. So the rule is about allowing consumers another option to, again, pool their resources and bring a case as a group as opposed to an individual, because as an individual with limited resources, it's really hard to take on a big corporation with deep pockets. And then in terms of the independence of the CFPB, Congress does have a way of checking the rules that the CFPB puts out under the Congressional Review Act, actually, which they've used, I think, since President Trump took office. They've used it about 14 times. It's a law that was passed, I think, in 1996. So it enables them to undo regulations that have been put forth.
All right, the New York Times' Jessica Silver-Greenberg joining us today from New York City. You can find her work at nytimes.com. You can find her on Twitter at JBSGreenberg. Thank you so much for joining us this morning.
Thank you.
And coming up, Christian Science Monitor's Simon Montlake will discuss his new piece on how the so-called Rust Belt is moving toward a more high-tech future. We'll be right back.